Hi, we're Richard and Jackie from Early Retirement Wanderlust.
We're all getting older, and one of the things that we can do right now for the people that we love and for our future selves is to put in place a lasting power of attorney to safeguard our future needs.
So in this video, we want to go through what actually is a lasting power of attorney, why do we need one, and go through 10 things that you should know when you're wanting to set up a power of attorney for yourselves.
For those of you that are new to the channel, we're Richard and Jackie, and we early retired in 2022 after a particularly traumatic 2021. In a very short space, I unfortunately lost my dad and I lost my disabled brother very, very quickly. And during that time, my dad was the primary carer for my mum, who has dementia, and my brother, who was disabled. So in a very short space of time, we had to go through very quickly and set up a lasting power of attorney to make sure that mum and my brother's needs were met when my father passed away.
So for my mum, it was very different. She actually came to me about 10 years ago with all these forms and said, Jackie, I've set up a lasting power of attorney for you and your sister to sign. And she sorted it all out herself because she saw that there would be a need in the future.
So currently we have two mums who are in very different circumstances, but we are lasting powers of attorney for them. And what it's done over that time is it's made us realise how important having a lasting power of attorney is in place so that your needs as an individual are met throughout your life, no matter what your circumstances turn out like. So let's get on with the video. Within the UK, there are two types of lasting power of attorney that you can apply for. The first one being health and welfare, and that's when your attorney can help make decisions for your overall health and well-being. So that could be to do with the type of medical treatment that you get or the care arrangements that are put in place for your future. Now, it's important to remember that this lasting power of attorney can be applied for at any stage, but it's only activated when you as the donor lose mental capacity. So that might be when you have been diagnosed with dementia and that decision has been made sometime in the future that you no longer have mental capacity.
And the second kind of lasting power of attorney is a property and financial affairs power of attorney. This again can be applied for at any point, and you as the donor can nominate two people that will help you make decisions to do with anything to do with your finances. And this one, interestingly, can be evoked at any point. You don't need to have lost your mental capacity. You can appoint an attorney that will help you to do your affairs, your banking, whether you're wanting to sell a property. In the case of Richard's mum, we are having to do that on her behalf.
It's important to remember that for both of these lasting powers of attorney to be legally binding, they need to be registered correctly, and that is done via the Office of Public Guardianship in the UK. So why is a lasting power of attorney so important?
It's a way of you ensuring that your interests are protected and your wishes are followed should something happen to you and you have no mental capacity to make those decisions for yourself.
It's really important to have a lasting power of attorney in place, particularly if you find yourself in a situation like my mum. We had a lasting power of attorney in place prior to her losing her mental capacity, and when that decision was made, it could have been a really difficult time, but the lasting power of attorney really helped me help my mum so I could take over her financial affairs. I'd always helped her with that, but it made things much easier when I was dealing with the banks and things like that. And likewise, when we had to make decisions about mum's long-term care that she was no longer able to make for herself, I could think back and almost be mum's advocate as to how she would want to be cared for in the future, and that made that process so much easier. If we hadn't have had that lasting power of attorney in place, it would have been a much longer and more protracted process that we'll go through later in the video.
From both our experiences that we've had through having been attorneys and also from a bit of research that we've done, we've come up with 10 things that we think you really should know about lasting power of attorneys.
So firstly, the most important decision is to who you are going to have as your attorneys. And it's a really important decision because these people are going to have quite a bit of power in terms of making decisions about your future. They need to be people that you trust, and they need to be people that are going to be acting in your best interest. As part of the process, you can specify whether they need to work absolutely together and be in agreement about any decisions that are made, or they can act separately. But that is all part of the process, and you can make that decision for yourself.
So when do these lasting power of attorneys take effect? Actually, the financial and property LPA can be used straight away with your permission, even if you have full mental capacity.
However, the health and welfare LPA is slightly different, and that only comes into effect when you have been judged to have lost your mental capacity to make decisions. You have to apply for a lasting power of attorney through the Office of Public Guardianship, and it can be quite a lengthy process. Filling out the paperwork doesn't take that long. However, it is a 20-week wait before you get your paperwork back and you can do anything with the LPA.
We actually found the registration process really quite easy. We did it online, but you can also get it done through a solicitor. Obviously, there would be an associated cost with that.
When we were applying for an LPA for my mum and my brother, who both had significant additional needs, we got loads of support from their GP practice, and they helped and guided us through the process, which was really helpful.
I suppose for us the main thing we found tricky is that you have to print the forms off and you do have to get them witnessed in a certain order, and just making sure that we'd dotted all the I's and crossed the T's to make sure we'd done that correctly was a bit tricky.
But we did find that the guidance online from the Office of Public Guardianship was really good, and it was written in plain English and even we could understand it, so it wasn't too difficult, so don't be put off by that.
There is an associated fee for registering your LPAs, and it is per LPA, so it's £82. And I think you can get reductions or exemptions if you're on certain benefits, so that's definitely worth looking into as well.
There are lots of safeguarding procedures put in place to make sure that you as the donor are well protected and your best interests are looked after. During the registration process, there needs to be a certificate provider or witness that is prepared to testify that the donor is fully aware of the requirements of the LPA and has got full mental capacity at that time. If there are any concerns about someone having mental capacity, that's the point when I would definitely engage with the GP, because they can become the certificate provider to say whether a person does or does not have mental capacity. And for us that was really important when we were applying for mum's LPA, because mum had been diagnosed with dementia a number of years previous. However, the doctor was quite happy at that moment in time to certify that mum still had mental capacity and still understood the implications of the LPA that she was signing.
And if memory serves me correct, I'm pretty sure at some point we got letters and your mum got a letter to say that an LPA had been applied for, just another layer of safeguarding for you as the donor.
So if a person is judged not to have mental capacity, then you have to apply to the Court of Protection to become a deputy.
A deputy's role is very similar to that of a power of attorney, but you do have to go through the courts and you are appointed by the courts, and there are a lot more checks and balances that you need to go through, and you're accountable and have to submit yearly, I think it is, reports back to the courts.
And obviously by applying through the courts, the whole process is a lot more protracted and it costs a lot more because you have to do it via a solicitor. So another main reason why it's really important to have a lasting power of attorney in place while you've still got mental capacity.
Even if you have your lasting power of attorney put in place, you can revoke or change it at any point. There are a few checks that you need to do.
If you want to make changes to your lasting power of attorney, that you write formally to the Office of Public Guardianship, and they will make sure that those changes are recorded on your lasting power of attorney. There is no one size fits all, and you can write it for your particular needs and your wishes. So for example, if you've got particular wishes about what you would want to do with your house or what care arrangements you would want to be put in place for you in the future, you can specify those in the lasting power of attorney. It remains in the document and it remains with the Office of Public Guardianship for future reference.
And finally, the LPA must be signed and witnessed in a certain order. First of all, it's signed by you as a donor. It then has to be signed by your certificate provider, which is your witness, and finally by the person that you've appointed as an attorney. So hopefully this video has given you just a little bit of an insight into what the lasting power of attorneys are. It's something up to about 5 years ago I really hadn't got a clue what they were and why they were so important.
Yeah, and with Jackie's mum, it was a really simple process. It was put in place in plenty of time, and it's something that we've never really had to work on. Whereas with my mum and my brother, it was really quite difficult because my dad was their main carer. So in a very short space of time, we had to make the applications and we had to make sure that everything was done and dusted really before Dad passed away, and that was a horrible time. So if we had our time again, I would always say just get a lasting power of attorney in place. It's not an onerous process, and what it does is it just safeguards your future self to make sure that you receive the best possible care and the care that you would want in your future life.
And just hopefully this video triggers something in you that you might want to go away and do a bit more research yourself, particularly if you're a certain age, like myself and Richard, because it is something that we will be putting in place in the near future, really, for ourselves, so our children know what our wishes are.
So that's it from us. We hope you found it of use, and we will catch you next time. See you later.
Bye.
Bye.